Welcome to the Spiggle Law Firm podcast, where we help people who've been fired or afraid that they might be, and we also like to talk about cutting-edge legal issues in the news. I'm Tom Spiggle, founder of the Spiggle Law Firm, and I'm thrilled to have a repeat guest with me today, one of our great lawyers, Zach Aman, who is going to be talking today about the Pregnant Workers Fairness Act. And as usual with Zach, we're going to have a sports angle to it, so that will be fun. But before we jump into that, a little legalese, because of these lawyers. This is not intended to be legal advice for listeners. This is an educational product in order to create an attorney-client relationship with our firm. If you'd like either of those things, then you've got it. You should hire a lawyer. All right, with that said, Zach, let's jump in and let's talk about the Pregnant Workers Fairness Act.
Sure. So, like you said, always having a sports angle. As you're aware, the WNBA season, regular season, kicked off in the last week or so. And so I was watching a game the other night, and I saw an interesting graphic. They always have the graphics about who's in and who's out because of injuries, things like that. And so there was a graphic that they showed on the screen that welcomed a couple of players back from injury. There was like an Achilles injury.
Once you were showing me before, why don't you hold up your phone? I think that people can see it.
Let's see. It might show backwards for you guys, but
that's okay.
So yeah, we've got Achilles, we've got knee injury, we've got Crohn's disease, but then we have baby and baby. And I just think that's an interesting way to either announce somebody's had a baby or it's listed on an injury report, but in certain situations are considered potential disabilities for work. And so that had me thinking about the Pregnant Workers Fairness Act. So, what is that? The PWFA, it went into effect June of last year. Now, about a month ago on April 15th, the EEOC issued its final rule on how it would regulate the PWFA. That rule goes into effect on June 18th of this year. So, while the EEOC has already taken cases under the Act, they now have a rule that employees can look to for guidance. So, at the federal level, prior to the PWFA, pregnancy discrimination in employment was either governed by Title VII or the ADA. And then Title VII, it was amended in 1978 by the Pregnancy Discrimination Act. So it amended Title VII to provide that discrimination on the basis of pregnancy, childbirth, or related medical condition is unlawful for employers to do. So that meant that any policy or employment decision that intentionally discriminated against a pregnant worker or had a disparate impact on them could be challenged in a similar way to discrimination cases based on any of the other protected characteristics of Title VII. So that's gender, sex, disability, race, national origin, things like that. So more or less, this just meant that the employers could not make decisions based on an employee's pregnancy status. So then what the Pregnancy Discrimination Act also did was it provided that women that were affected by pregnancy, childbirth, or related conditions shall be treated the same as all employment-related purposes or other persons not so affected, but similar in their ability or inability to work. So what this meant is that employers could not treat pregnant workers differently from similarly disabled workers. Right. So that just means that pregnant employees are entitled to the same accommodations as those that a comparable another employee with a comparable temporary disability. But here's the catch. If an employer doesn't regularly provide accommodations to anyone, then it doesn't have any obligation to accommodate the needs of a pregnant worker. And that's even if the accommodation would be very, very minor and nearly, no cost to the employer at all. So while pregnant workers had a right not to be discriminated against based on accommodations that other coworkers would have, they didn't have that right independently. And so that's what the Pregnant Workers Fairness Act was designed to kind of bridge that gap. So the Act requires employers that are otherwise covered by Title VII to provide reasonable accommodations that are necessary based on pregnancy, childbirth, or medical-related conditions, unless it would be an undue hardship on the employer, just like the other accommodations would. So the Pregnant Workers Fairness Act, again, modeled after the Americans with Disabilities Act, or the ADA, and it grants employees an affirmative right to a reasonable accommodation, regardless of how employees are treated, how other employees are treated by the employer. So it's different disability, that doesn't matter anymore. They have their own independent right. So the deal is, the Pregnant Workers Fairness Act, it only applies to accommodations. So, the other laws like Title VII, the ADA, that make it illegal to fire or discriminate against employees based on their pregnancy, childbirth, or related medical conditions, those still apply. The Pregnant Workers Fairness Act was not intended to circumvent those laws. It just goes for accommodation. So similar, since it's based on the ADA, the procedures for filing a charge are similar, as well as the remedies, damages are the same as well. So whoever satisfies the definition of an employer or an employee under, Title VII, the ADA, the same as the Pregnant Workers Fairness Act.
Yeah, no, I think it's a great topic and a really important one, because as you raise, for years, decades, there was this kind of gaping hole between the Pregnancy Discrimination Act and the ADA, and we had these sort of weird cases where, women were at the time legally fired because they didn't have a pregnancy that, could be shoehorned into the ADA or was absolutely, was definitely covered by the ADA. And by that, I mean, they had some interference with some major bodily function. And of course the ADA was amended and liberalized. So before that happened, we had a lot of situations where, for instance, like you'd have somebody on a, that works retail and needed to go to the bathroom more often. They didn't have a disability; they were just pregnant, and their bladder was getting squeezed. They needed to go to the bathroom more often, and they would, in some instances, be fired for that kind of, very benign request, and there was no law that covered them because, the employers were able to say, we provide this rule is the same for men or for women, so we're not discriminating you on the basis of your pregnancy. That's just how we roll here. And then there was no recourse because you couldn't request. There was no grounds for you to be protected for requesting an accommodation. So we had situations where, people with counsel who knew what they were doing, would try to get these women covered under the Americans with Disabilities Act, because a lot of it, as Zach, being covered by that act is how you position it. Like, what is it that you are saying to your employer when you're requesting this? And there are, ways that you can word it and things that you can say that are more likely to get you covered under the ADA. So it was really unfortunate. I mean, it was a workaround, and we were able to do it in our office, and others were too. But for people who didn't have counsel or weren't as sophisticated about it, they would send Joan Williams, who's sort of the godmother of caregiver discrimination law out of University of Hastings at what's the name of the group? Anyway, I'll come to her in a minute. Work-life law. So she joked, like, these people were sending their employers, "Please fire me" letters, right? Because they were just saying, "Hey, I need this change," and they weren't wording it in such a way that could get them covered by the Americans with Disabilities Act. Along comes, as you point out, the Pregnant Workers Fairness Act, that really fills that gap. So now you don't have to try to, if you're covered under the ADA, great, you can certainly proceed under that. But it's really, as you indicate, very similar to the Pregnant Workers Fairness Act. So it means if you're a woman, you're pregnant, you're at work, if you're covered for a covered employer, which is most employers with 15 or more employees, if you need a workplace change on the basis of your pregnancy, you are protected. You have a legal basis to request that accommodation, and then the same mechanism that comes in as an ADA to engage in some kind of interactive process. So, as you pointed out with your graphic I'm sure they didn't intend anything ill by that, but we still kind of struggle, even this modern day employers, to kind of get it right with regards to pregnancy and not treating women at work like there's some kind of ticking time bomb because they might be or are pregnant. So they're still working on that. So it's good to have these protections because, we see in our office every day, the pregnant workers still are facing some very difficult, not all of them, but can face very turbulent times in the workplace. So it's nice to have this added protection.
Yeah, I agree. I mean, I have to imagine that being discriminated against for being pregnant while also going through a pregnancy is probably not the most fun. So it's nice that this has given some more teeth to what we're able to do. I know you mentioned that before there were people who just weren't using the right language in how they were talking to employers, and I thought that was another interesting thing about the Pregnant Workers Fairness Act is because in prior federal law, it's all about who's an otherwise qualified employee or applicant, right? And so the Pregnant Workers Fairness Act actually has two different definitions of who would be qualified. So the first one, it's very similar language from the ADA. It says an employee or applicant who, with or without reasonable accommodation, can perform the essential functions of the employment position is a qualified employee or applicant. So that's pretty straightforward. But there's an added one now. It says the PWFA allows an employee or applicant to be qualified even if they can't perform one or more of the essential functions of the job, if that inability to perform is temporary. And they could perform the functions in the near future. And the inability to perform those functions, those essential functions, could be reasonably accommodated. So there's still some gray area as far as the language goes, but it helps a little bit more. The statute itself, it doesn't define what temporary means, what in the near future means, or what can be reasonably accommodated means. The Act itself doesn't do that, but the final rule that's going into effect next month gives a little more guidance on what that means. So under the rule, the term temporary means lasting for a limited time, not permanent, and may actually extend beyond in the near future. So there's a little difference there between the rule and the Act itself, which will be interesting to see how it plays out. But under the final rule, if an employee is pregnant, it's assumed that the employee could perform the essential functions in the near future because pregnancies, typically only last about 40 weeks. Some a little less, some a little more for some people. But again, it's once the pregnancy is over, the pregnancy is temporary. It's not permanent. So they should be able to resume those functions. Now, that doesn't mean that every single person is going to get it just because the nature of the pregnancy. It doesn't mean that every accommodation would be reasonable. Or that every request will be granted. The rule just states that whether an employee could perform an essential function in the near future is to be determined on a case-by-case basis. So you at least have to have the conversation or, some of the buzzwords, engage in the interactive process. You have to be able to talk back and forth with your employer about what is reasonable under the circumstances. But again, I think the Act and then the rule that's been implemented to control how the EOC reads the Act gives a little more teeth for pregnant workers.
Yeah, absolutely. And those are all great points about the Act and how it differs slightly, from the ADA, which I think is an important point. So, and we'll put the link in the show notes for the EEOC. It's just the EEOC.gov. They provide some great guidance on this, and you can find their proposed rules on their website. And they really do. Their guidance usually is written for lay people because it's also written for employers to be able to implement this. So they are very good about providing examples and very non-lawyer speak about how the Act is going to be applied. So it's worth folks checking out there. And just remind folks, if you're find this complicated or you're struggling with your employer, come see the lawyer, whether it's us or somebody else. You don't have to hire the lawyer to suit up and run off to court or even deal with your employer, but sometimes it can be helpful just to know, the lay of the landscape, and like if you're going to file a charge, how to file a charge and when to do it, and generally just how to, best position yourself so you are enjoying the full benefits of the law. So, all right, Zach, anything else you want to talk about on this?
No, that's it. I'll keep my eyes peeled for some other sports stories and see how they can be generalized to the general public.
That's right. I always appreciate it. It gives a nice angle to sometimes what can be dry topics. So I appreciate that. Well, thanks for joining us today on the Spiggle Law Firm podcast, where we talked about the Pregnant Workers Fairness Act. And Zach Aman gave us some really good detail on that, and used an example of how the WNBA is announcing people that have been out because of a baby, which I thought was an interesting, provide some interesting color to this topic. So if you found this helpful, you like other information like this, you can go to our website, thecareerrocket.io, and you can give us your email. You will get an email once a week where you'll get the latest and greatest in employment law, and you'll get tips and tricks on how to keep your career on an upward trajectory. If you found this episode helpful, if you could send it to a family member or a friend, we're trying to get the word out to as many people as we possibly can. So good luck out there, guys, in the meantime, and we'll see you on the next episode.